two resolutions we have some questions about, so I'm going to roll those to the heel. Actually, the second and third. So we will begin with, if I can have everyone's attention, we will begin with RS 2016-159, sponsors O'Connell and Pride Moore. This enters into an alternative license agreement with Greyhound Lines. I have a letter to approve. Is there a motion? Second? All right. Any questions? Seeing no questions, all those in favor? Opposed? Okay, the next two items we are rolling to the heel until those questions are answered. So we will move on to BL 2016-162, sponsors Roten, Allen, and Elrod. This abandons an existing unused sanitary sewer easement located at 1176 Stones River Road. Lots of sponsors are here. Do we have a motion? Been moved and seconded. Any questions? Seeing none, all those in favor? Any opposed? Bill is recommended. Next is BL 2016-163, sponsors Davis, Allen, and Elrod. This abandons an existing sewer main and easement and accepts new sewer mains, manholes, new water mains, and fire hydrants for property located at 1414 Rosebank Avenue. It's been moved and seconded. Any questions? All those in favor? Any opposed? Like sign. Bill is recommended. Next is BL 2016-164, sponsors Withers, Allen, and Elrod. This abandons an existing sewer main and manhole and accepts a new sewer main, manhole, and easements for property located at 970 Woodland Street. Do you have a motion? Great. It's been moved and seconded. All those in favor? Any opposed? Bill is recommended. Next is BL 2016-165, sponsor Mina Johnson, Henderson, and others. This abandons existing sewer main and accepts new sewer main and easements for properties located along Linwood Boulevard and Abbott Martin Road. I have a note that there's a proposed amendment. Does anyone know anything about that one?
Yes.
Okay.
Simply adds the word Martin.
Oh, this adds the word Martin after Abbott. So do we need to vote on the amendment and then the bill? Is there a movement? Is there a motion on the amendment? Okay, we are voting on the amendment. All those in favor? Aye. Any opposed? Like sign. Now we are voting on the bill as amended. All those in favor? Aye. Any opposed? As amended. Great. Next are bills on third reading. BL 2015-20, sponsor is Freeman. This changes 3.02 acres from OL to RS and RS10 to SP zoning for properties located at 100 and 102 Thompson Lane to allow uses permitted under OR 20A zoning district. Been moved and seconded. Are there any questions? Seeing none, all those in favor. Mina, question, Councilmember Johnson. Yes, ma'am.
Thank you, Madam Chair. Just a quick clarification, because I have not seen any site plan for this ordinance, and it has introduced and deferred and come back in a quite long time. So I would like to ask clarification. I'm thinking this is a conceptual SP rather than a site-specific SP, and also would like to ask Bill's sponsor where the communities are. I'm assuming we do not have any opposition at the public hearing, so communities on board, but I just wanted to make sure.
Thank you. I'll start with planning and then move to the sponsor.
You are correct. This is what we refer to as a regulatory SP. So the site plan, or the plan, is actually a regulatory document that is included in the P&Z report.
So, and would the sponsor like to speak? Mr. Freeman.
Thank you. If you want to see a conceptual drawing, I have that, and I'm welcome to email that to you. On the front, facing Thompson Lane, it's going to look like your typical brownstone, and the buildings behind will be of a cottage style. The community, for the most part, is on board. I mean, the biggest complaint is just traffic on Thompson Lane. That's just been our biggest complaint, but we're only adding 42 units to the flow of traffic, and we don't feel like that's going to be a big enough an issue.
Thank you. Councilmember Coleman, you don't need to speak. Yes, sir.
Madam Chair, I was trying to get you to speak up to the microphone. I had a difficult time hearing you. I didn't have anything on this bill, but we just couldn't hear you back here, so that's what this press of the button was about.
Great. Okay, any other questions? Okay, it's been moved and seconded. Are there any other questions? All those in favor?
Aye.
Any opposed? Bill is recommended. Next is BL 2016-117, sponsor Syracuse, Freeman, and others. This amends the Metro zoning code to designate flex loan and installment loan as uses permitted with conditions and adding conditions applicable to these uses. I understand there is another amendment. Would you like to speak to that, council member?
This is for, thank you, Madam Chair. This is for 117.
This is for 117.
Yes, I'd like to move the amendment. Basically, we are utilizing 117 to give an actual definition to flex loans.
Okay. And is that what the amendment does?
Yes, ma'am. I'd like
Okay,
to move
so
the-
we're voting on the amendment.
Ma'am.
Any other questions on the amendment? All those in favor? Any opposed?
I'd like to move the
Right.
bill as amended.
All right, now we're voting on the bill as amended. All those in favor? Any opposed? Great. Next is BL 2016-132, sponsor Syracuse, Mina Johnson, and Sledge. This amends the Metro Code pertaining to financial institutions and alternative financial services. Been moved and seconded. Councilmember Syracuse, if you can tell us the difference between these two.
We have an amendment on, this is 132, right?
And this has a proposed amendment. Would you tell us about the amendment?
This basically gives the definition for financial institution as opposed to alternative financial services and includes the hours of operation definition.
Correct.
So I'd like to move the amendment.
Okay. The amendment has been moved and seconded. I see no questions. All those in favor?
Aye.
Any opposed? All right.
I'd like to move the bill as amended.
Okay, now we are voting on the bill as amended. Seeing no questions, all those in favor?
Aye.
Any opposed? Oops. Bill is recommended. Next is BL 2016-135. Sponsor is Sledge. This changes 5.2 acres from IR to SP zoning for properties located at 1131 and 1137 4th Avenue South to permit a mixed-use development. Councilmember Sledge. Okay, it's been moved and seconded. Any discussion? All those in favor? Any opposed? Bill is recommended. Next is Bill 2016-136. Sponsor is Hastings. This changes 0.19 acres from R6 to MUGA zoning for property located at 2004 3rd Avenue North. I do not see the sponsor. Let me look for a letter. I do have a letter asking for approval. Is there a motion and a second? Any discussion? All those in favor? Any opposed? Bill is recommended. Next is BL 2016-137, sponsor is O'Connell. This changes 3.79 acres from IG to SP zoning for property located at 1400 Adams Street to permit a mixed-use development with up to 20,000 square feet of non-residential uses and up to 259 residential units. Been moved and seconded. Anyone wishing to speak? Seeing none, all those in favor? Any opposed? Bill is recommended. Next is BL 2016-138. Sponsor is Sledge. This changes 0.17 acres from IWD to MULA zoning for property located at 2420 Cruzen Street. Been moved and seconded. Any discussion? Seeing none, all those in favor? Any opposed? Bill is recommended. Next is BL 2016-140. Sponsors Vircher Johnson. This amends a portion of the Carrollton Station Planned Unit Development Overlay District for property located at 308 Carrollton Station Drive to require the traffic improvements within Metro Public Works December 9th, 2004 recommendation. Is there a motion? Second? It's been moved and seconded. I do see some speakers in the queue. I will begin with Councilmember Glover as soon as I find his button. There. Councilmember Glover.
And Madam Chair, maybe I need to wait for 141 because I specifically would like for Mr. Jameson and then perhaps Mr. Cooper to talk to us about this memo that came out regarding this and the potential of a lawsuit and our odds of what would occur there and what cost could be. So if I need to wait to 141, perhaps that may be a more appropriate
Let me ask that
time.
question. Would it be more appropriate to have that discussion when we get to 141?
Because it does apply to both.
It does apply to both, so perhaps we should go ahead and answer that question now. Okay. Oops, I should. Okay.
We have received correspondence from an attorney named Larry Crane, who is somewhat famous among council members from the previous term because he was plaintiff's counsel on a matter entitled Teen Challenge. And he has made clear in his correspondence dated March 7th that if this should pass, he's instructed to proceed to protect his client's interests upon the allegation that the ordinances are in violation of 4 statutes, perhaps a 5th. The statutes that he cites are the Fair Housing Act, the Americans with Disabilities Act, the Religious Land Use and Institutionalized Persons Act, and the Vested Property Rights Act. He might also allege a violation of the Tennessee Religious Freedom Restoration Act. This is a very difficult situation, and I will say, personally and candidly, I've never seen a council person break her back more to derive the will of her constituents and see that get done than Council Lady Vercher. Having seen this happen in 2008 and 2009, it's a concerning situation. Under the ADA and the FHA, an individual is formerly incarcerated and has a substance abuse issue or is seeking treatment for that, is classified as disabled and therefore protected under federal and state legislation. And that protection includes any discrimination based on zoning or local municipal actions that would even slightly impose their ability for housing, for development. And they have asserted that in their letter of March 7th that they intend to proceed on those grounds under the FHA and the ADA. Men of Valor is claimed to be a religious organization. Their website does claim a religious affiliation. They have that in their bylaws. And they do claim that they treat formerly incarcerated men with addictive behaviors. And therefore, they would likely qualify under the FHA and ADA as protected classes. This particular case was also made very difficult by the fact that the original PUD was passed in 2004 by then Councilman Jason Alexander, who has no recollection of the events now, as you can imagine, having occurred 12 years ago. There was a recommendation within the Public Works report to the Planning Commission that essentially 2 lanes be corrected at intersections off Una-Antioch Pike and Blue Hole Road and Hickory Hollow Parkway. For reasons no one knows and no one can recall, those recommendations did not make it from Public Works recommendations to the final bill passed then by Councilman Carl Birch, who took it over, we believe, because Jason Alexander then developed a conflict. The 2 bills include one that is simply trying to reinsert that traffic intersection fix because it is horribly congested there, and this development is going to contribute to that. But is there a possibility that we would be sued because we are slightly imposing, even slightly imposing, upon a facility that provides services for the disabled? That risk is there. You do not even have to show that your primary intent is a discriminatory animus. It doesn't even have to be the main reason that you pass the bill. If it's one reason, for example, if you are concerned about the congestion that this might cause, but you also have worries because your constituents don't like formerly incarcerated members with substance abuse problems, that's a violation of the Fair Housing Act and ADA. I cannot give you a black and white answer as to whether or not, A, we would be sued, and B, would we prevail, because it is so fact-specific. Mr. Crane's letter does quote from sources quoted in the Tennessean as essentially stating they don't like this bill, they don't like this development because it would reduce their property values and it would increase the level of crime because of the nature of the people that receive treatment there. That may be factually incorrect, but that is a huge red flag to anyone that suspects there's a discriminatory animus, not on the part of the council member, but on the part of the constituency that voted or has attended community meetings in opposition to this. The FHA strictly protects the rights of individuals to be grouped homed, to be housed in group assemblies and to live in a group home such as what's been proposed here. The fact that there is neighborhood opposition cannot overcome the potential violations of the AHA and the FHA, ADA and FHA. There are several cases from the Sixth Circuit that resemble this quite closely. There's a case out of Covington, Kentucky, where a former offender group home that provided substance abuse activities, substance abuse drug facilities, and the neighbors were fearful of illegal activities by virtue of the nature of the patrons there, zoned it out of existence, and were then successfully sued. And that was cited in the letter that you received March 7. Discrimination on the basis of drug dependency fears is antithetical to the Fair Housing Act and the ADA. That's the very purpose of that legislation. And as frustrating as it is for constituency and for this council, that is the law that we must be concerned about. What is deeply distressing to the Sixth Circuit is anyone that cites a pretext. You can cite specific reasons for what you're trying to do, but if the court suspects that there was an underlying discriminatory animus, you can then be found guilty of that. The discriminatory intent can be inferred from the subtlest of things that have nothing to do with the council member's intent, but from the constituency's intent. And that's what makes these so dangerous. As I mentioned before, discrimination need not be the sole motivating factor. Now, in this particular case, it is fairly easy, I would think, to demonstrate there has been a lengthy history by council members in the southeastern portion of this county of resisting developments of all descriptions, because of the lack of infrastructure and the stories that you've heard repeatedly, that we don't have the school facilities, that we don't have the infrastructure, the streets and the sidewalks to support this development. And that is what Council Lady Vircher has maintained throughout these proceedings as far as I can tell. Because again, these are so dependent on the specific underlying facts, I can't guarantee success and I can't guarantee that we wouldn't be sued. The last series of laws that we're being challenged under are essentially religious liberties, something called RLUPA, Religious Land Use and Institutionalized Persons Act, which essentially states this: no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person. That includes facilities as well. If you have a compelling state interest that you can demonstrate that you are pursuing in lieu of any discriminatory basis, that may mean success on your part. The problem is that what a compelling state interest is defined as something that prevents a substantial threat to safety, peace, or order, and that's a tall burden. And that's a burden that we may or may not overcome in this case. I would conclude by saying I can't tell you if we'd be sued, and I can't tell you that we'd lose. But I can tell you that there is a risk of both, and that's as much guidance as I can offer you without a crystal ball.
And the council lady, I know you have worked hard on this. I think we have to be concerned. Is Ms. Lamb here?
No, she's not here, but...
Okay, Mr. Cooper, then can you help me understand the last sentence of this memo that came out to us from her, as far as specifically, however, since men of valor's rights are vested and thus the ordinances are unenforceable against them, it is questionable whether they would have sustained actual damages. Can you kind of interpret that?
Sure. The strongest legal argument is that their rights are vested. I mean, I think that is if I were representing them, I mean, that is by far the strongest argument and the easiest to prove. So our advice to the zoning administrator was that their rights are vested, so really these two ordinances, even if they pass, would not be enforceable against them. So the question is whether, if the ordinances are not enforced against them, have they been damaged in any way? The only way that I could see that possibly being the case would have to do with financing. If a bank held up financing or refused to finance because that they were not in compliance with the zoning. I mean, that's the only way I could see that they would be damaged, potentially. So that's what that sentence means.
And this would be, if in fact they proceeded with a lawsuit on this would be in federal court?
Yes.
And is there a dollar limitation as to what the damages could be determined to be?
There is not. I was here when we had the Teen Challenge case, very similar facts. The award or the damages that Metro had to pay was about $1 million, just shy of $1 million. You also have to pay the attorney fees and court costs for the plaintiffs.
Okay, thank you. Thank you, Madam Chair.
Councilmember Vercher.
Thank you, Madam Chair. Yeah, I know this is.
Oops, sorry. You're back on.
Can you hear me?
Yes.
Thank you, Madam Chair. This is a complex issue, and I would like to state that both bills have nothing to do with the proposed tenants. These bills both address the density and infrastructure, and we have overwhelming support for the community that's asking for this. These bills provide the balance that's needed out there on that corridor. The reduction in density is comparable to the new development, existing development, the development that's occurred over the last 11 years as well. The infrastructure part of the bill, that is a housekeeping bill. That bill does not discriminate. That is us being good stewards, doing good governance, and correcting a wrong. That's all that bill does. That's the only intent for that bill. In discovering what was actually going on with this PUD. It's been missed for 11 years, and we have an obligation as a body to correct this. The community knows that the infrastructure should have been done, and that's all the intent of these bills are. They're not discriminatory. The infrastructure, again, is a housekeeping bill. The reduction in density is just making the project more comparable to what's actually transpired in 11 years out in the Antioch area. Many of us know, we hear the political sound bites that Antioch is one of the fastest growing areas in Davidson County. We live with that every day. The neighbors are asking for us, they're looking to us to make sure that we control the density and that we get the infrastructure out there in our area. I also want to stress, these two bills, they do not stop the project. These two bills does not infringe on the use of the project. Actually, in both of these bills, there's no mention of the actual use. These bills only address the density and the infrastructure, and these bills will be applicable to any developer that's coming to that area.
Thank you, Councilmember. Councilmember Karen Johnson.
Thank you, Madam Chair. I will not repeat everything that Councilwoman Vercher has mentioned, but she's on point with everything that she has said. In regards to these bills, they do not, again, affect use. And also, to make note on these two bills, please note that the Planning Commission staff also recommended approval of both of these bills at the initial hearing at the Planning Commission. And so that is something to consider. If we were infringing on anybody's rights or anything of that sort, I don't think that there would have been an initial recommendation for approval for both of these bills. But I think the biggest thing that Councilwoman Vercher has mentioned is that this doesn't affect any future or proposed tenants. The person that owns this property or the entity that owns this property is a for-profit corporation. And so Men of Valor is only a projected or proposed tenant. This action does not affect them in any way. So we ask for your approval.
Thank you, Councilmember. Councilmember Glover, do you wish to speak again? You're good.
Thank you. Mr. Jameson, let's come back to that. So just trying to, and again, let me emphasize, I want to be supportive of the council member. This is her district, and she has worked extremely hard on this. But help me understand, and maybe Mr. Cooper, you as well, with regards to the vesting, that the current owner is a for-profit ownership, and this is a potential tenant. So help me understand that piece of it, please.
Vesting is almost a pass. If the property is deemed vested and is not going to be enforced by Metro, then what this body does is almost irrelevant. I hate saying that, but if it's not going to be enforced, then the question is, what violations, what harm have they suffered? I think that was kind of the intent of the last line of that memo. In terms of the ownership of it, my understanding from what they've submitted in writing is that the listed owner, Jericho Properties LLC, has as its sole member Men of Valor. The website cites some sort of business relationship with Corrections Corporations of America. I don't see any specific tie other than the fact that they've apparently engaged in projects in the past, but there's no ownership overlap as far as I can tell. If the property is vested, and that's, again, their primary argument, it would be because they obtained their final site plan on January 6th. And the Vested Property Rights Act that just passed in 2014 and just went into effect a year ago January, so there's not a lot of case law on this, but essentially states that whatever the land development policies are in place at the time that you get in Nashville your final site plan, that's what they're entitled to rely on, and we can't yank the rug out from underneath them in the meantime. But I want to echo that Council Lady Vercher, in all of her discussions before this body, has never suggested anything with any remote discriminatory animus towards the clientele. The problem is going to be if there are constituents that are apparently quoted in the news media that may feel differently. In the Teen Challenge Act, what was particularly problematic is that the council member had a variety of televised community meetings where individuals stood up and said, I have concerns about teen substance abusers, and that was used against us pretty remarkably and dramatically well.
Okay, so with regards to it being vested, and I'm going to come back to Mr. Cooper on this because this would be Metro Legal, I assume, that would be defending this. With regards to the vesting, if we pass these bills, then it doesn't do anything to them. They can go ahead and proceed.
The legal department doesn't issue permits, so, we would not be the ones making that decision. We have advised the zoning administrator. The zoning administrator asked us to look at it and determine whether they were vested. We did that. We advised that the rights are vested and the bills would not be enforceable. Ultimately, it would be up to the zoning administrator to make that determination, but he did seek out our advice and we advised him accordingly.
Okay, thank you, Chair.
Councilmember O'Connell?
All right, I think I'm on. Madam Chair, I'm curious to know, I guess, hearing, and I have to thank our speaker for bringing up the point that there was a distinction between staff recommendation and the commission's perspective here, but I think this might also start to get at a little bit of a broader question, which is, as we go forward and we know that Southeast Nashville is growing quickly and we hear infrastructure concerns, I keep coming back to, all right, well, we're seeing a lot of growth in different parts of the city. If we continue to approve projects and if this one didn't wind up invoking a traffic study in its current configuration, what do we mean when we actually say infrastructure, right? I mean, if we're not doing anything on a planning basis or public works basis to actually impact transit or mobility options, to me, the infrastructure is always going to be lacking. I know we don't have a representative from Public Works here today, but I wonder if planning staff have a perspective on this of, all right, if we go forward here, and this body acts in a way to limit the impact of land use here on congestion at that intersection, still, I think the long-term view citywide is we're going to continue to see rezoning requests, and if they continue to increase density, how are we ever going to have the infrastructure keep up with those requests? So I'd love planning staff's perspective on that.
Planning?
Sure. We've had several recent requests from council members to start looking into the issue of how to evaluate infrastructure and specifically traffic improvements more cumulatively, so that we understand and Public Works understands how projects that may be approved but not yet constructed are affecting the future traffic situation, and it is something that we intend to start looking at.
Councilmember Coleman.
Thank you, Madam Chair. It's going to take me a few seconds here. I'm from the Southeast. I feel the growing pains and have felt them. But also, I was on the council in 2008 and 2009 when we were sued by Team Challenge. And even though the emotions run deep, it's what we press in our voting. And all of us stand in jeopardy when we act and we get the advice. So having said that, I want to ask a few questions, and then I'm going to propose a motion. Mr. Jameson, would you define for us what a declaratory judgment is?
Declaratory judgment is absent an actual lawsuit. It's a declaration by the court as to the legality or the position of one party as opposed to another. You go to a court without actually filing suit and seek a resolution of a question of law, a question of fact.
Now, because we have been hit and put on notice that this body could stand in jeopardy in our city, that a possible lawsuit can be filed, and we could find ourselves defending a lawsuit as we did in Team Challenge if this body pressed the green button and we vote for this. Is that correct?
Correct.
So if in fact we were to stop at this point and defer and ask for a declaratory judgment in that regard, would that give us the necessity to be able to really understand the impact if we decided to go forward without having damaged one bit the opponent in this case, which mean the owners of the property?
I'm going to have to think out loud about that. So there's no third and final action by this council. So there's no approval, there's no final act that prejudices the owner-developer. Now, they may state that because they're under a cloud of pending legislation that it disrupts their financing or something to that effect, and I can't promise you that wouldn't happen. And then in the meantime, preferably with the owner's participate in declaratory judgment. That would be unusual. I can't see any reason why it's prohibited, but I may have to get back to you on that in the morning. Mr. Mendez has an answer, I think.
Push your button.
Yeah, that's true. What Councilman Mendez and Mr. Cooper say is there has to be an actual controversy, not a hypothetical, although I think we may.
Well, Mr. Cooper, you could join in as well. As I understand it, this is a controversy because this council is saying that they support or they will support council-rated virtues bill. The other side is saying if you go forward with this, you're going to jeopardize us. So we're asking for some court to give us direction and guidance so that we can make a decision. Now, maybe I'm wrong about what I know about declaratory judgments, but it has always been the case that you're trying to get court's guidance before you make a move either left or right.
Typically, declaratory actions are to determine whether something is or was not right. The courts do not like to weigh into hypotheticals, and they do not like to try and provide guidance to legislative bodies. I would be very surprised if the court would make a ruling in such a case.
Well, and John, and you can say right there, here's the point. The Planning Commission, and when this zoning initially took place, okay, we can't find evidence that certain things were asked for. And so, in a sense, this bill deserves to move forward on the idea that the infrastructure should have been there, because this was done some years ago. And I just think that if, in fact, we have a bunch of lawyers on the other side of a decision made by this council, somewhere we need court intervention in order to support what might be correct and what we might think is a moral wrong. Now, you heard Council Lady Johnson and Council Lady Virtue tell you about the impact. Well, we feel that, okay? However, back when this was first started, 2000, whenever this was first passed, Men of Valor, there were ideas that the infrastructure should have been there. Is that correct, Mr.?
Correct.
Okay. It was not put into a bill. We can't find that right now.
Let me clarify that. So in 2004, 2005, when this was originally proposed, Men of Valor was not in the picture. This was owned by a separate entity that we believe went bankrupt or went out of business after the economic downturn. Sorry, but with that slight clarification, you're right.
Okay. So I'm just thinking that as important as it is to us and to this council person carrying the bill, we just don't need to be in the position to take the opinion of those who say that our action may be illegal. And I would suggest that we can file a declaratory judgment, and we can get guidance from the court, and that it would be prudent to defer this matter, because certainly no one here in this body want to hit their button knowing that we can possibly be sued. That's just not something we'll have a good feeling about. But we want to be supportive of the council person. So to do that, the people on our side of the coin should lead the question for us whether or not what we're about to do on third reading is something that can be enforceable. Then I think this body would have a better idea and a better sense. And to do that...
And I'm sorry, I know I'm cutting you off, but you may be going in a particular direction, and I was just going to offer, if the intent is to find out if this is eligible for a declaratory judgment, and I don't know that yet, but it does have to be a matter in controversy, and whether or not this would meet that burden, we don't yet know. But if your intention was eventually to offer a brief scheduled deferral, this committee, I think is Rule 24, gives you the unfettered right for a singular deferral for a period of time during which we and Metro Legal Department would determine with greater certainty the declaratory judgment eligibility, if that's where you were going.
That's exactly where I was going, and I appreciate the help there. I'm getting a little wound up because I too feel the emotion of our community. I know they're listening, and I want them to be clear. There's nobody backing out, but we need more legal guidance. This is more than an emotional issue. This city was hurt and damaged when we did Teen Challenge. So therefore, members of this body, of this committee, I'm asking for a 2-week deferral for the purpose of Metro Legal and our council office looking into this to give us the possible ways that we can make a determination as to whether or not we want to go forward with this bill. So again, I'll renew my request for a 2-week deferral in order for Metro Legal as well as counsel from council office to advise us the legality from a legal and from the attacks that were alleged to have occurred in this letter, saying that we acted illegal on our first 2 votes. Not illegal,
you're
but
applying that
improper.
motion to both bills, I assume, 140 and 141.
Exactly. Yeah, they travel in pair.
Is
So
there
that
a-
is my motion.
Do we need a second for a motion?
We do.
Is there a second? I have a number of people in the queue that haven't been able to speak yet, so I think we need to deal with the... Point of order. Yes, sir.
Meeting for 3 weeks.
Right. Duly noted. So 1 meeting deferral, I think, is what you're asking for. Is that correct?
That's correct. Thank you, Councilman
Great
Glover.
statement.
1 meeting deferral. And Madam Chair, I think that when I make the motion, I think we have to take up the motion and vote on the motion at this point before we have more argument. Is that?
If it has been seconded. Okay, the motion to defer 1 meeting has been seconded. I have a number of people in the queue. If you are in the queue and you want to speak on the motion to defer, let me know. Councilmember Sledge.
Speaking on the motion to defer, I would ask that we consult the
sponsors of the bill before we take a vote as to how they feel about the one meeting deferral.
Fair enough. Councilmember Vercher.
Thank you, Madam Chair. I am comfortable with the one meeting deferral. As I stated earlier with both these bills, there's no malintent, there's no discrimination as it relates to either one of these bills. The intent of these bills is just simply getting it right. And a one meeting deferral will afford us as a body to get these right. I also want to note there's reference of Teen Challenge. Don't construe these two bills with Teen Challenge, totally different. One, my intent is not to zone the developer out from actually moving forward with their project. That's not the intent of either one of these bills. So don't confuse Teen Challenge with the intent of these bills. It's about addressing the density in the area and righting a wrong of infrastructure that should have been amended to a bill 11 years ago that was not. We're righting a wrong here. I'm okay with the one meeting deferral because we need to get it right.
Thank you. There are other members in the queue. Do any of those members wish to speak on the one meeting deferral? Councilmember Johnson, would you like to speak?
Yes. I'm speaking to the deferral, and again, I concur with my fellow Councilwoman Vercher, and support the one meeting deferral because it is a matter of getting it right. But I do want everyone to understand that there's a possibility to be sued in any decision that we make. And the actions that we have taken with these two bills would apply to any developer or owner of this property. It is not directed at any religious entity or any intent to do that at all. We have no control over the potential tenants that this property owner decides to place on their property. This is a for-profit entity, and we're treating them as we would any developer. And I do have a question for Attorney Jameson, and that is, in 2014, when the law was changed relative to vesting rights, my understanding is that that law was changed somewhat behind the action that the council took on my bills relative to the PUD that we revised in Nashville Village. And the reason for that change to that law doesn't apply in this particular situation, because what happened in the Nashville Village PUD situation was I reduced the number of uses and the type of uses that were in those parcels. And so therefore, after that decision was made, which was legal, and we were even advised then that we could potentially be going against the owner's property rights, but of course, as everyone saw, we did not. And then they lobbied the state legislature to change the state law, which ultimately addressed uses. Now, my bill and my properties in Nashville Village are grandfathered in. But the reason why I bring this point before all of you all is we had that same potential of being sued that was conveyed and communicated during that time when I was trying to pass that bill. And of course, things happen after we passed it as a council successfully to make sure that things that we do in this body don't occur in that manner going forward. So that's my question. Can you please clarify if that was the reason for the change to that state law that you mentioned shortly ago to Councilman Glover?
Well, I have long heard that the state legislature acted in response to that situation, so you are to be commended for advocating for your district. The sad fact of the matter is that the black letter law now provides that if you had a certain zoning provision at the time you obtain your final site plan, you're entitled to that, and nobody can come change it afterwards. Councilman Hager recently endured the effects of the Vested Property Rights Act. The state General Assembly has not for the first time, frustrated the will of this body. Councillady Gilmore and I co-sponsored legislation that then got turned right around, and I understand how frustrating that is. But right now, what's on the books is a law that says that once they obtain their final site plan, and they obtain that January 6th, they're entitled to a site plan that allows them 60 units instead of 30, and nothing about fixing those intersections. I really wish they could and wish they would, but that is the status of the law that I'm obliged to tell you about.
I'd like to, planning, can you address the question of the intersection? Did the January 6th deal with one of the intersections? Am I remembering incorrectly?
It required a turn lane into the development.
The entrance.
It required a turning lane, but not the intersection. Okay, thank you. Thank you for that. Are there any others who wish to address the one meeting deferral? Councilmember Gilmore.
Thank you so much, Chair Allen. My question to Mr. Jamison was, I wanted to know what they had to do, what are the council members' rights in terms of just carrying the bill? Are they required to carry the bill even though the developers have not met with the community? And they're doing a rezoning. To me, that's just a little bit unusual. I understand about the disability, the religious rights, but most of the time, you cannot get away with that. If you're doing a community meeting, a rezoning, normally it's the practice, because you're actually helping the developer, that they meet with the community and you try to usually reach a consensus. So that's just my question. Are they required to carry that forward, and how can they not meet with the community if they're carrying that bill?
Right. I don't have much legislation to offer you because, and just as a personal perspective, the fact that an owner or developer would not meet with the community is enormously frustrating, and they certainly should. I think they're going to argue that they did meet with the community, and I'm not trying to weigh in on that dispute. But in terms of legislation, are you required to enact a zoning request when they refuse to meet with the community? There's nothing that prevents or requires that.
But I'm just talking about in general. If you do not think a development is good for take the religious piece out of it, take if you did not think that a particular bill was good for your community, are you required as a council member to carry that bill forward?
Well, if it's serving a community that is a protected class, for example, those that are deemed disabled, even though many may dispute that description, this is a class that is entitled to that protection under two potentially significant federal statutes.
Can I also have Mr. Mr. Cooper speak to it as well? Thank you.
Yes, Mr. Cooper.
Well, I think a distinction is that in this case, these are not zoning bills that are brought by the property owner. The property owner did not need any zoning to proceed. In fact, the property owner got their final site plan in January. So, to the extent the property owner was trying to have the property rezoned and failed to meet with the community, then no, council members sponsors have absolutely no obligation to move forward with the legislation.
Thank you. Any other questions on the motion to defer? Hearing none, we are voting on the motion to defer one meeting. All those in favor? Aye. Opposed? Like sign? Mr. Jamison, can you tell me if we need to now vote separately on the second bill? Or okay, so we're going to move on to BL 2016-141. Been moved and seconded. Is there any discussion on the move to defer Bill 141 one meeting? Seeing none, all those in favor? Aye. Opposed, like sign. Thank you very much. Next is BL 2016-142. Sponsor is Scott Davis and Allen. This changes 0.26 acres from IWD to RM20A zoning for property located at 805 Cherokee Avenue. I have a letter to approve. Is there a motion? Been moved and seconded. Is there any discussion? I'm assuming everyone is still in the queue from the last one. I'm going to blank you out. You're cleared. Okay. Any questions on this one? All those in favor? Aye. Any opposed? Motion is approved. Bill is approved. Next is BL 2016-143. Sponsor is Roberts. This changes 0.36 acres from IR to R6 zoning for property located at 4603 Kentucky Avenue. Do I have a motion? Been moved and seconded. Is there any discussion? All those in favor? Any opposed? Bill is recommended. Next is BL 2016-144. Sponsor is Kendall. This changes .41 acres from R6 to CS and CS to RM20A zoning for properties located at 410 and 412 36th Avenue North and 36th Avenue North, unnumbered north of Charlotte Avenue. I do not see the sponsor. Let me check for a letter. I don't see a letter. I will roll this to the heel. If he appears, we'll take it up when he gets here. Next is BL 2016-145, sponsor Scott Davis. This changes .62 acres from CS to MUGA zoning for properties located at 18, 20, 22, and 27 Legan Avenue. I do have a letter to approve. Is there a motion? It's been moved and seconded. Is there any discussion? Seeing none, all those in favor? Any opposed? Bill is recommended. Next is BL 2016-146, sponsor is Henderson. This changes .83 acres from CS to SP zoning for properties located at 5644 and 5648 Franklin Pike Circle to permit a 6-story hotel of up to 100 rooms. Sponsor is here. I have a motion and a second. Is there any discussion? Seeing no discussion, all those in favor? Any opposed? Bill is recommended. We'll go back to the two bills with the mystery amendments. Did we learn anything about those? There are no amendments. Okay. So we are back to RS 2016-160, sponsor O'Connell and Elrod, authorizes the Renaissance Hotel to construct and install an aerial encroachment on the bridge at 611 Commerce Street. Been moved and seconded. Is there any discussion? Seeing none, no amendments. All those in favor? Any opposed? Bill is recommended. Next is BL 2016-161, sponsors Allen and Elrod. This authorizes the Belcourt Theater to construct and install an aerial encroachment at 2101 Belcourt Avenue. There is no amendment. Do we have a motion? Do I have a letter? The sponsor is sitting here. Right. I'll write you a letter. Thank you. I appreciate that. Do we have a motion? Been moved and seconded. Any discussion? All those in favor? Any opposed? Like sign. All right. Has Councilmember Kendall appeared? I do not see that. That is all of our items. I would like to wish everyone a happy Pie Day, and there is pie in the kitchen. With that, I move for adjournment.